While some of the provisions of the Constitution deal with rights retained by individual citizens, others define the powers held by the government. One of these provisions is the Commerce Clause, which grants the federal government the ability to regulate commerce between the states.
The Commerce Clause is in Section 8 of Article 1 of the Constitution, which lists all the powers that the framers gave to the U.S. Congress. And it includes things like providing for defense, establishing post offices and roads. And the Commerce section provides that Congress shall have the power to regulate commerce among the several states. Those are the words.
And if you look at the vast range of things in federal legislation today, the single most important power, just measured in terms of sheer number of words and the sheer number of legal provisions, is the power to regulate commerce.
In recent years, the Commerce Clause has been the focus of controversy over the balance between state and federal authority. On one side are originalists and libertarians who argue for a limited view of the federal government's power to pass laws and wish to preserve a greater role for state legislatures. On the other side are modernists who argue that interstate commerce can have a broad meaning and can empower Congress to pass a wide variety of laws. The Supreme Court's earliest Commerce Clause decision was Gibbons versus Ogden, decided in 1824. In that case, Chief Justice Marshall affirmed that the Commerce Clause allowed Congress to regulate interstate economic activity, including river navigation. Subsequent Commerce Clause decisions have created two separate but parallel histories, each dependent on the perspective of the interpreter.
The commerce power, as defined by Chief Justice Marshall, endured for quite a while until really the end of the 19th century, when the country was undergoing explosive industrial development and economic growth. And there was very much a laissez-faire economic theory abroad, which had its impact on the Supreme Court. And what the Supreme Court did during that period, really from about the turn of the century until 1937, was strike down progressive legislation to deal with the bad side effects of industrialization, like labor problems and health and safety issues and monopolies and price fixing. Whenever the states or the federal government tried to deal with those, the court would hold that these were beyond their powers. I regard that as the medieval period of Commerce Clause jurisdiction.
Many originalists and libertarians view the decisions of that same era not as aberrations, but as part of a tradition of limited federal power that was broken by court rulings which favored President Roosevelt's New Deal economic policies.
During the Progressive era, at the turn of the 19th to the 20th century, we saw a fundamental shift in the climate of ideas. The Progressives no longer thought of government as a necessary evil, as the founders did, but started thinking of government as an engine of good, an instrument through which to solve all manner of social and economic problems. And so they started to engage in a program of political activism. The problem, of course, was that the Constitution was written for limited government.
The time will soon come.
When the focus of their activism shifted to the federal government from the state level, during the New Deal, that's when things came to a head. Roosevelt threatened to pack the court with 6 new members. There was a reaction in Congress against that. Nevertheless, the court got the message, and the court began rewriting the Constitution.
Know only too well.
In the Jones and Laughlin case in 1937, the court read the Commerce Clause as a power to regulate anything that affects interstate commerce. That, of course, allows Congress to regulate anything and everything because there is nothing that does not at some level affect interstate commerce.
The court's broad reading of the Commerce Clause expanded over the course of the 20th century to include many things that did not fall squarely within interstate commerce. In the wake of these decisions, Congress passed laws regulating a wide variety of non-commercial activities, such as bans on the possession of firearms near schools.
You can't take something that has nothing to do with interstate commerce and then justify it under the Commerce Clause. The whole superstructure for the regulation of economic activity is basically a Commerce Clause activity. So the degree to which you expand or restrict the interpretation of that clause is the governor on just how far the government can go in making decisions that perhaps in an earlier day would have been left to the states or the individuals.
A broad reading of the Commerce Clause has also allowed the enactment of many federal environmental laws that protect wetlands and endangered species.
Well, most of the modern environmental laws that are regulating that area of our life today were enacted in the 70s and early 80s, and there's probably a dozen of them. And they were based in large part on its authority to regulate the national economy under the Commerce Clause of the Constitution. And if you look at the results, it's been one of the most successful programs in the post-war period here in the United States. We've seen since 1970 population growth of nearly 50%, and yet pollution has gone down. And our view is that you should not tamper with that kind of success, and Congress deserves credit, not challenge, for putting that framework in place.